I'm Tudor Nagu. I'm an immigration attorney, and I'm fortunate enough to lead the litigation department at Wilds & Weinberg, which is a storied immigration practice in Midtown Manhattan. I want to talk to you today about Biden's new Keeping Families Together program, also known as Parole in Place. It was announced on June 17th, implemented on August 19th, and enjoined by litigation in the Eastern District of Texas on August 23rd, which means that it was essentially stopped. But they are still accepting parole in place applications on Form I-131F. They're just not adjudicating them as of today. That temporary stay has been extended through September 23rd. And so I want to briefly go over the program, who qualifies and who doesn't. Most of you have probably heard of this program by now. And I also want to go over the Texas litigation and the most recent updates on that front. A few housekeeping notes first. None of what I'm about to tell you should be interpreted as legal advice. It is not. It is just a discussion of publicly available information. You should talk to an experienced immigration attorney before making decisions in your own case. Okay, with that out of the way, let's talk about the Parole in Place program. So very basically, when an individual files for a green card, there are two big forms that they file, which is the petition and the application. The petition is filed by the petitioner in the United States, and the application is filed by the foreign national themselves, and they can file that in the U.S. or abroad at a consulate. The reason why one would be forced to file abroad is because the first requirement of filing in the U.S. is to show that you entered with inspection, meaning that you're admitted or paroled under INA 245A. So anybody who did not enter with a visa or a passport or any kind of documents, they cannot file for green cards domestically. Prior to the Parole in Place program, the remedy used to be filing a consular application and then filing an I-601A stateside waiver. The downside with that waiver is that it currently takes about 4 to 5 years to process, and one would have to show extreme hardship to a qualifying relative, typically a spouse or a parent who's a U.S. citizen or green card holder. And of course, there's risk in going abroad, because anytime you go abroad, a different ground of inadmissibility could crop up that may lead to your being stuck abroad. And so enter Parole in Place. Again, the requirements for this program are that you entered without inspection, and so anybody who entered with a passport or even with a false passport technically does not qualify for this program. You have to show that you were present in the United States as of June 17th of 2014 through the filing of the I-131F. Brief and casual departures do not disqualify you, do not interrupt this physical presence. You have to show that you're legally married to a U.S. citizen as of June 17th of 2024. So marriages after that date disqualify you, and if your spouse does not become a citizen until after that date, that also disqualifies you. And finally, you have to not have any disqualifying criminal background, and I'll discuss that further as well. Stepchildren also qualify for this program so long as they entered without admission or parole as of June 17th of 2024, and they are currently unmarried and under 21, and the qualifying stepchild relationship existed as of June 17th of 2024. There is a difference in physical presence for stepchildren in that they only need to have been in the U.S. as of June 17th of 2024 and not 10 years prior. Okay, so let's briefly go over the application process itself. These applications are only filed electronically, so there's no paper filing. The first part is basic biometrics, pretty typical of all USCIS applications. This, by the way, is a test application. It's not anybody's application in particular. Okay, this question is a little bit tricky. So they're asking for your most recent I-94 arrival departure record. That would be evidence that you entered with inspection. And so as this note suggests, obviously if you entered with inspection, then you do not qualify for this Parole in Place program. Okay, and here if you have previously been ordered removed from the United States, you would answer yes here. And as you can see, this note indicates that you are presumed ineligible for parole in place under this process unless you can establish that there are significant favorable factors that outweigh the removal order, Okay, now this question, have you ever been arrested for, charged with, or convicted of a crime? So please notice that they're asking for arrests, right? And so if you're arrested but then charges were dropped, you would still have to answer yes here. Here they ask if you've already filed an I-601A waiver. If you have and you have an approval, you should upload that approval in this process, as they are prioritizing individuals who have approved 601A waivers. Okay, and in this last text box, they're asking you to describe the significant public benefit that granting parole in place for you would convey on the United States, and what urgent humanitarian reasons there are warranting a grant of parole in place. I will leave it to you and your attorney to determine what that public benefit is, but I will remind you that in the Federal Register notice, these benefits are described as stabilizing and unifying families and enabling non-citizens to contribute more fully to the United States economy, and the fact that once approved, you could file for adjustment of status, reducing inefficiencies in the process and helping out DHS and USCIS with their workloads. Okay, last but not least, as identifying documents, you want to provide your valid government-issued driver's license, photo ID, passport, identity page. As to evidence of your relationship with your U.S. citizen spouse, you'll want to provide their U.S. birth certificate, naturalization certificate, and marriage certificate to show that you're married to one another. And as for evidence of continuous physical presence, the primary one you want to look at are IRS tax transcripts. Those are the documents that they're going to be interested in most, as well as evidence of cohabitation, so joint leases, joint mortgages, joint deeds, hospital records, and a bunch of other things that they list here. Under additional evidence, this is where you'll want to upload either your I-130 approval, the petition approval, or your waiver approvals. For 601As, your I-212s, those get uploaded here. So let's talk about who can and who cannot apply for this program. First and foremost, individuals who enter with inspection, as mentioned, cannot apply. So if you enter with a visa or passport, this won't be for you. Individuals who are permanently barred from the United States under INA 212A9C do not qualify. So what does that mean? Well, if you previously entered, overstayed, and then left, or were ordered removed and then left, as soon as you depart the United States, there's a bar against you, either 5 years or 10 years or longer. If you then re-enter without inspection, right, walk across the border during that bar period when you weren't allowed to come back, then you are deemed to be permanently barred under INA 212A9C. And if that happened to you, then unfortunately you would not be able to file for this parole in place, and you also cannot adjust status. Okay, anybody who has pending criminal charges against them cannot apply for this program. So any kind of criminal charges that are pending other than moving violations would disqualify you. Anybody who has a felony, which is a crime that is punishable by more than 1 year of detention, also is disqualified from this program. And then they mention specific types of crimes that would disqualify. These are very horrible, terrible crimes that I'll let you read off the screen. Anything other than these terrible crimes, felonies, or pending criminal actions, anything other than that, you may apply, and the government will consider mitigating factors such as rehabilitation, the age at which you were convicted, the age at which this crime was committed. I think it should be obvious that if you have criminal charges or a criminal past, you should use an attorney to file this. Okay, now individuals who were previously removed from the United States and did not leave. So if you have been in front of an immigration judge or failed to go and have a removal order against you and you never left, those individuals are presumptively ineligible for parole in place under this process. However, DHS will evaluate applications and consider on a case-by-case basis the facts and circumstances underlying the unexecuted final order of removal, and you may overcome the presumption of ineligibility and be granted parole. So it's not a lost cause, it's just that the odds are stacked against you. Now, you should also know that if you have an outstanding removal order if you are granted parole in place, in order to adjust status, right, for the next step to file for a green card, you will have to dispose of that removal order, either reopen it or dismiss it or deal with it in another way, so as to shift jurisdiction back from the Executive Office of Immigration Review, right, Immigration Court, back to USCIS. Okay. What about individuals who are currently in removal proceedings? So USCIS has said that they will consider those applications on a case-by-case basis, taking into account the totality of the circumstances under this process. What that most likely means is that they will look at the reason why you're in removal proceedings, and if the reason for it is because of criminal charges or convictions, that will probably be considered more seriously than if it is a simple overstay. Again, use an attorney to file those if you are currently you probably already have an attorney at that point, hopefully. So let's discuss the Texas litigation. As I mentioned, on August 23rd, 16 states led by the state of Texas sued DHS over the implementation of the Keeping Families Together program. So what was their argument? Well, what they're arguing is that parole in place was meant to be administered on an individual case-by-case basis, and they're complaining that by standardizing the process and make it available to a wide swath of people, estimated between 500,000 and 750,000 individuals, they're arguing that this en masse or a large-scale application process goes counter to the initial intent behind parole in place, which was to consider each case individually. And they also take issue with the idea of paroling individuals into the United States who are already here, because the statute at INA 212 D5 describes individuals being paroled into, uses the word into the United States. And if those folks are already here, then their argument is that it doesn't make sense logically. Okay, on August 26th, Judge Barker in the Eastern District of Texas issued a 2-week administrative stay that was extended through September 23rd and set a bench trial date for dispositive motions on September 18th. However, on the same day as the order, the Coalition for Humane Immigrant Rights, representing individuals who applied for parole in place, filed a motion to intervene, asking that they be joined as defendants in the case alongside DHS. That motion to intervene was denied by Judge Barker, holding that there isn't a need for an additional defendants because DHS will represent the interests of all defendants. The coalition appealed that order denying their right to intervene as defendants to the Fifth Circuit, which is the appellate court that's above the Eastern District of Texas. The coalition argued that actually their clients have different and more extensive interests than DHS. First, DHS has institutional interests, so these are things like foreign policy, national security, public safety, border security, things that perhaps parole in place applicants may be less interested in. And also the coalition argues that there are other individuals outside of this Keeping Families Together program that also have an interest in keeping parole in place valid. These are perhaps individuals from Cuba, Haiti, Nicaragua, Ukraine, Venezuela. Those people are eligible for parole in place under different programs. And so if parole in place fails under Keeping Families United, those people may also be precluded from filing for parole in place under different programs. The coalition makes a bunch of other arguments that I won't go into. They have provided a very thorough and well thought out brief to the Fifth Circuit. But there is one thing that I want to point out that the coalition states in their brief at footnote 3, which I found interesting, which is that they said that in this case, conflicts between or misalignment of interests may not yet have arisen between DHS and the intervening defendants. So what could the coalition possibly mean when they say this? Well, one guess, and this is just a guess that I'm making, is that we have an election coming up. If the administration changes next year, perhaps to a Republican one, then indeed the goals of DHS will then have changed. At that time, the coalition and DHS may indeed have conflicting interests, even if they don't have conflicting interests now. So in a way, the coalition may be seeking to insert itself as an additional defendant to insulate against the possibility that a new administration would stipulate to the dismissal of this case potentially in the future. I'm not sure how effective this strategy is that the coalition is pursuing, because if indeed we have a new Republican administration, that administration would almost certainly remove this program, and this litigation would probably be marked as moot. I think they're trying to reserve the right to continue fighting. But again, if we change administrations, I think it'll probably be a losing battle. One other thing that I'll mention briefly is that on September 6th, an attorney by the name of Robert Hegman filed a petition for a writ of error coram nobis and a motion for declaratory judgment alleging that President Biden and Vice President Harris have committed crimes against humanity and genocide. It is an unusual filing, given that this is a civil proceeding to be alleging criminal conduct by the president. But it was filed nonetheless, and I will leave that there. All right, I hope this has been helpful. I'm hoping to upload an update on October 10th or shortly thereafter, once the Fifth Circuit hears the appeal in the Texas litigation, and hopefully I will see you then.